Good day, madam. We are from L2T13. Our group members include Tammy Lee, Tan Yi Kai, Puvarasan, Ho Ze Hui, and Priyanka.
My name is Tammy. I'm the senior partner at Lee & Partners. To begin our discussion today, I'd like to share a short film that we have prepared. It highlights how arbitration operates in Malaysia, its strengths, its challenges, and what it means for businesses and employees. This video will provide a clearer picture of the role arbitration plays in resolving disputes and set the stage for our discussion in a while. Arbitration in Malaysia has become a key way to settle disputes outside the courts. Guided by the Arbitration Act 2005 based on the UNCITRAL model law, it promises flexibility, efficiency, and confidentiality. The Asian International Arbitration Center, or AIAC, plays a central role in promoting this process. Yet, arbitration is not always fair. In consumer contracts, clauses are often hidden in the fine print, from credit cards to online services, blocking access to the courts. In contrast, Malaysia's Tribunal for Consumer Claims offers a faster and cheaper route for smaller disputes, ensuring real protection for consumers. Mandatory arbitration clauses are now everywhere. While businesses see them as efficient, they often arise from unequal bargaining power. For individuals and small companies, this means being locked in a process they never truly chose. Employees face the same challenges. Arbitration clauses in employment contracts may limit access to remedies under the Employment Act 1955 and the Industrial Relations Act 1967. If arbitration undermines workplace justice, it fails its purpose. Arbitration should be more than fast and private. It must also be fair and just. To remain legitimate, it must balance efficiency with the protection of consumers and employees, ensuring justice is never compromised.
Hello, Mr. Tan. My name is Hui. So I recently encountered disputes regarding to my gym membership, which I signed up for. So under the gym membership contract, it stated that all those disputes must be referred to arbitrations under the institutional rules. So I assume that me myself as a consumer, I can bring any case or any issue before the tribunal or consumer claims, which I understand meant to be a more speedy and low cost forum. But now I'm concerned that arbitration may be costly, formal, and inaccessible compared to the tribunal. So my question is that does this clause mean that I cannot go to the tribunal, and is it fair to me?
All right, thank you for your questions. So basically, consumer protection law in Malaysia is primarily governed by the Consumer Protection Act 1999 (CPA), which seeks to safeguard consumers against unfair practices and imbalance in bargaining power. According to Section 10 Sub 1 of the Arbitration Act 2005, a court before which proceedings are brought in respect of a matter which is the subject of an arbitration agreement shall, where a party makes an application before taking any other steps in the proceedings, stay those proceedings and refer the parties to arbitrations unless it finds that the agreement is null and void, inoperative, or incapable of being performed. This principle was further affirmed by the Federal Court in the case of Press Matter Sarawak Sdn Bhd and Etika Takaful Berhad 2016, where it was held that arbitration agreements must be construed according to their terms and circumstances and that parties are generally bound to honour what they have agreed. In contrast, Section 6 of the Consumer Protection Act 1999 prohibits contracting out of its protections, declaring void any clause that attempts to exclude or restrict the rights conferred by the statute. Thus, an arbitration clause that prevents consumer from bringing disputes before the tribunal could be rendered invalid. Further, Section 24A of the CPA defines an unfair term as a term in a consumer contract which, with regard to all the circumstances, causes a significant imbalance in the rights and obligations of the parties arising under the contract to the detriment of the consumer. Hence, arbitration clauses imposed in standard form contracts, particularly where they limit consumer remedies or increase costs, are likely to fall within these definitions. So the Tribunal for Consumer Claims has been established under Part 11 of the CPA was designed to offer low-cost, accessible, and efficient dispute resolutions with jurisdiction up to 50,000 ringgit and simplified procedures. Therefore, while businesses maintain that arbitration ensures efficiency and finality, in practice, arbitration clauses in consumer contracts are more harmful than protective unless consumers voluntarily and knowingly choose arbitration. Such clauses undermine consumer choice and contradict the spirit of the CPA 1999. Thank you.
Hello, Mr. Puva. I'm a small business owner and I often enter into supply contracts with larger corporations. So these contracts are normally invariably include a mandatory arbitration clause. And I found that I have very little ability to negotiate, and I'm worried that if there's any disputes arise, I will be bound to arbitrate under terms that are costly or inconvenient to me, particularly. So my question is that, are these clauses enforceable, and how do Malaysia court approach them?
That is an important concern. The enforceability of an arbitration clauses in Malaysia is governed by the Arbitration Act 2005. Section 9 of the said Act requires arbitration agreement to be in writing, whether as a separate agreement or to a clause within a broader contract. Section 10 obliges the court to stay proceedings commenced in breach of an arbitration agreement unless the agreement is null, void, incooperative, or incapable of being performed. Equally significant is Section 18, which enshrines the doctrine of competence, allowing arbitral tribunal to rule on their own jurisdiction. Malaysian court has emphasized the sanctity of arbitration agreements. In Albit Resources and Casaria, the Federal Court highlighted the binding effect of an arbitration clauses, stressing judicial deference to party autonomy. This approach was reaffirmed in Press Matter Sarawak Sdn Bhd and Atika Takaful Berhad, where the Federal Court ordered a stay of proceeding in favor of the arbitration, emphasizing Malaysia's obligation under the New York Convention 1958. More recently, the Court of Appeal in Yong and Lam and Infinity Wantage Sdn Bhd confirmed that court must stay proceeding unless the arbitration clause is proven incooperative. Similarly, in Casa Armada Sdn Bhd and Shapodo Energy and Engineering Sdn Bhd, the High Court affirmed that jurisdictional challenges fail primarily within the arbitral tribunal's power. From the comprehensive perspective, the European Union Directive deems arbitral clause in consumer contracts potentially unfair, and many member states limit their enforceability unless both parties voluntarily agree after the dispute arises. In the United States, the Federal Arbitration Clause strongly enforces arbitration clauses, but reforms such as the Ending Force Arbitral of the Sexual Assault and Sexual Harassment Act 2022 demonstrate recognition of limits. In Malaysia, however, court continue to prioritize contractual freedom and enforcement of arbitration clause, consistent with its aspiration to be seen as the arbitration-friendly jurisdiction. Thus, for small businesses like yours, arbitration clauses are firmly enforceable, though they may perpetuate inequality in bargaining powers.
See. Anyway, thank you, Mr. Puva. Hello, Miss Priyanka. My name is Hui. So I recently dismissed from my job, and I believe that it was without just cause. But I noticed that my employment contract requires all disputes to be resolved through arbitrations. So I also take knowledge that there's a Industrial Relation Act and other statutory rights. So my questions and my worry point is that does this clause, this existence of arbitration clause, will prevent or may prevent me from filing a claim under the Industrial Relation Act? And does this mean that I lose all my statutory rights?
Thank you for sharing your situation. In order to understand this better, firstly, we need to look into the law. The Industrial Relations Act 1967 provides a mandatory framework for unfair dismissal claims. Under Section 20 of the Act, workers who feel they were fired without cause or explanation have the right to file a complaint with the Director General of Industrial Relations, who may also send the matter to Industrial Court. Remedies such as reinstatement are statutory in nature and cannot be substituted by arbitration. One of the disadvantages faced by the employees can be seen in the case of Michael Lee Fuqua and Minister of Human Resources Malaysia and another. The Court of Appeal limited judicial intervention by ruling that the minister had absolute discretion to send unfair dismissal allegations to the Industrial Court. This implied that a worker's right to file for arbitration for an unjust dismissal was reliant on ministerial approval rather than being automatic. The case demonstrates how the broad discretion granted by the minister under Section 20, subsection 3 of the IRA can serve as a barrier, depriving employees of important remedies from the very protection that arbitration is intended to offer in cases involving unjust dismissal. However, Malaysian courts have confirmed these limits. In Justin Clements and Matrix Global Schools, Matrix Global Education Sdn Bhd, the Industrial Court held that an arbitration provision in an employment contract does not require employers to participate in arbitration, because doing so, it would go against the purpose of IRA, which is to safeguard the employees. Similarly, in the case of Pan Global Textiles Berhad, Pulau Pinang and Ang Beng Tek, it was held that statutory structure cannot be overridden because Parliament intended for claims involving wrongful dismissal to be settled through public processes that protect workers' rights. Therefore, although through arbitration there have been unwanted implications such as waiver of protection and restricting transparencies from employees, the arbitration clause in your employment contract does not deprive you of your statutory rights under the IRA. The Malaysian courts have adopted a practical stance upholding arbitration when it is appropriate by prohibiting its use to subvert statutory plans or the public interest. You may still proceed before the Industrial Court. Thank you.
Thank you, Mr. Priyangar.
To conclude this formal client consultation on arbitration, arbitration is vital for resolving disputes, but its fairness is often questioned. While it is effective for commercial parties, it can disadvantage consumers and employees. To stay credible, it must be reformed to ensure choice, protect rights, and uphold true fairness in dispute resolution. Thank you.